Good evening to everybody. Good evening to all the fellow chartered accountant. And shall I start, sir?
Yes, Mohit, you can please.
Good evening to fellow chartered accountants. I, CA Mohit Jain, moderator of this today's 85th webinar conducted by CPE Committee of Institute of Chartered Accountant of India on Digital Personal Data Protection Act 2023 and compliance under new labor codes. I, Chartered Accountant CA Mohit Jain, delightful to welcome you all on this webinar, which is being apprised by Continuing Professional Education Committee of ICI. Please, I request to all of you to please be in the today's webinar for getting the knowledge on the highly upgraded skills of the today's day about digital personal data protection and labor and new labor codes. For this, we are having our two eminent faculty, CA Chetan Kulkarni ji, CA Uday Kulkarni ji, and CA Uday Agarwal ji on their respective topics. I am also thankful to the chairman of this committee, CA Satish Kumar Gupta ji, and the vice chairman of this committee, CA Vishnu Kumar Agarwal ji, for believing to take the new topics, the new standards for maintaining the knowledge and the skills of the chartered accountants. I also request to the chartered accountant, those who are into the webinar, you may also ask the question by clicking on the link over the, which have been provided to you while you register for the webinar, and your question will be taken up after the end of the webinar. Now with this, let me introduce our today's Now, let me introduce our today's faculty and our today's eminent expert on this first topic that we are going to take for the day by CA Uday Kulkarni ji from Patan, Maharashtra on Digital Personal Data Protection Act 2023, along with their key provisions, key takeaways, and professional opportunities for chartered accountant. Let me introduce about our first speaker of the webinar, CA Uday Kulkarni ji. He is a practicing chartered accountant with over 28 years of professional experiences in banking audit, information system audit, cyber security, forensic accounting, fraud investigation, and IBC advisory. He is a fellow member of our Institute of Chartered Accountant of India, IIA from USA, ICASA from USA, and holds multiple qualifications including FCA, CIA, CISA, CDPSC, and insolvency professional. He himself is in panel faculty for the ICI certificate course on forensic accounting, concurrent audit, and prevention of money laundering, and has delivered lectures at prestigious institutions such as National Forensic Science University, RBI Academy, and SFIO. He also contributes as a member of the ICI expert group on forensic accounting and investigation standard. With this, all about of our eminent speaker of the day of this today's evening on the topic Data Protection Act 2023. Now let's to welcome our speaker of the today's webinar, CA Uday Kulkarni ji, on your positions with a huge round of applause to welcome our speaker of the today's webinar of the day of this evening, CA Uday Kulkarni ji. The participants are requested to please mention your questions, which is going to be take away after 450, sorry. At 4:50 p.m., we are going to take away the questions with our speaker, with our faculties, after concluding the today's topic that is going to take by CA Uday Kulkarni ji. Sir, you are requested to please take the webinar on the behalf of CPE committee. I again welcome you to giving you a valuable time for this our committee to address our participant to address our chartered accountants on the very emerging topic of the day, Digital Protection Act. Sir, you are requested to please take the dais and start your session. So please.
Okay. Thanks, Mohit. Thanks for your kind introduction. And good evening, all the participants. Wish you all a very, very happy festival season across all the countries we are enjoying today. Uh, all of us know the lot of discussions are going on this Digital Personal Data Protection Act 2023. And in November 25, the rules are also been notified. So every entity, everyone is gearing up for its compliances. This is a very important act from the perspective of everybody's digital personal data, because something that is very close to every person. And as a chartered accountant, as a professional, we need to understand that this act is having a wider impact, like a GST, because the every entity who is collecting the data for whatever be the purposes, legitimate purposes, it is provided here in this act. They have to ensure the compliances of this act. Of course, the chartered accountants, they are using a lot of clients' data in their practices, or even if they are in the employment, their entities, their organizations, they are also using a lot of digital personal data. So obviously, the compliances is required from the chartered accountant firms in practice. The chartered accountants who are there in the employment, they have to, their entities also have to make the compliances of it. And of course, all other entities, whatever be the size of that, all of them are expected to make the compliances about this act. It doesn't matter that there is no classification that only the sizable kind of an entity they have to make the compliances, because there are certain doubts that only sizable entities like the banks, insurance companies, they are expected to cover and they are expected to make the compliances of this act. But that is not the case. And even the small even shopkeeper, let us assume that it is a medicine shopkeeper, and he is also collecting a lot of data. First, he asks you what is your name as a patient, and he also asks you the mobile number. So for him also, the compliance of this Digital Personal Data Protection Act is mandatory. So it is a widespread act. It doesn't classify between the small and big entity. Yes, there is a one classification as a significant data fiduciary. We'll talk about that. But that is the reason I can say the act is giving opportunities for chartered accountants. So there are challenges, there are impact of this act, and chartered accountant has to identify what are those challenges, what is the impact of this act which is going to happen on their practices, and what can they contribute to the nation by advising or by in various capacities to their client. So all this information we will discuss in, let us say, next 45 minutes, because last 10 minutes, as Mohit quite rightly said, that is for the question answer session. For understanding of this act, we need to understand what is the purpose of this act. So purpose of this act is to protect the individual personal data which is widely used across the digital domain. Now we as a principal here, we are the person whose data is getting used on various digital platform. That person is called here as a principal. We'll discuss that also. But when we share the data across the various digital platforms, websites, or even when we go to the various entities like the hospitals, banks, shops, malls, right? So when we are traveling with various modes, so we share a lot of our personal data. And that data is now getting resided in the digital way in the form of some bits and bytes like as data. And that will be there for quite a longer period of time, right? So one has to, and we know that what is the value of our data. We in India, we do not have that kind of a concept to understand the value of our data. What is the value of my name, my mobile number, my email ID, my PAN number, right? Why this is so? Because within the 3 hour journey, if suppose we are traveling with a co-passenger in a train for 3 hours, within that 3 hours, we come to know each other's pura khandan, right? What is happening, who is troubling whom, what are the issues, what are the achievements, and all the story. And there we do not stop ourselves by sharing a lot of experiences within. So this is the nature. This is the natural instinct of Indian society. But what is happening really, someone, the fraudsters or the hackers or some notorious person, they are taking the advantages of this shared data, and they are trying to make certain amount of frauds by this data. We cannot imagine that, but that is the real things. And that's why the protection of this personal data on the digital domain, on the widespread digital area is very much essential, and other countries have done that. It's not only India is doing that. Of course, the other countries, if you can see, it is started by the European Union, then followed by the US, the various states in the US, and so on and so forth. So, all other countries are also equipped with or enacted this kind of an data protection. And the world is creating an ecosystem. So it is necessary under the European Union Act that is known as a GDPR that they will now do the businesses with only those countries who are also having the equivalent amount of act which will protect the personal data. So now every country is taking care of their citizens. Of course, there is a difference between the privacy and the digital personal data protection. This act is not about privacy. This act is about the protection, because privacy is the fundamental right which is available in the constitution. So there should not be any thing which you are going to discuss about that. Privacy is totally different, and data protection is totally different, and that is quite nicely explained in the judgments. So again, I'm not going into that legal aspect also. But yes, there is a difference between privacy and the protection. And here we are going to discuss as the law is enacted for the protection of the personal data. Purpose of this, one more purpose of this act, as I mentioned here, is whatever the data is going to be shared, that needs to be used only for the legal purposes. And why this provision is important, because many of the times you might have experienced that you have shared so much amount of the data with various entities. And suddenly you start getting a lot of SMS, lot of messages, even somebody is adding you in the WhatsApp group, and thereby they are starting sharing something. And you don't actually, you take a note that how this is happening, who is sharing my number, who is sharing my email IDs, right? So a lot of questions we are tagging each other that ये कैसे हो गया? And that should not happen actually. So that's important. What is the intention? Why every entity is collecting the data? What is the purpose? That is very important. And whatever be the purposes, only for that purposes, whatever be the personal data, that needs to be used. So these are the basic three purposes, objectives for which this act is enacted. First, we need to understand what is data, what is digital personal data, and what is personal data into that also. So there is a lot of definition under the Information Technology Act about the data. Even in this act, the data is defined. So it can be any information, any fact, concepts, opinion. That could be any data. What is personal data? Personal data means the data by which an individual, here we are not talking about entity, please understand. The act is about individual. So there could be some questions whether it is applicable for as a legal entity. No, it's not for the legal entity, it is for the individual. So personal data related to the individual human being, right? And what is personal data? An individual human being that can be identifiable by this data. So normally we know by what the individual is identifiable. Mostly the name. I wonder sometimes in the history when the first person, the first human being on this earth who has given a name, that is something amazing, right? And from that, the tradition is still going on that we are giving names to the individual human beings. And we cannot imagine now the world without our name, isn't it? So the name is the first thing by which we get identified. Our PAN number, of course, for the income tax purpose or for other purposes, That one more thing that can be pointed out to us, that this is the person to whom this PAN belongs to, Aadhaar number, or you can see our driving license related details, voters ID, right? So all these are the our date of birth, our address, our nickname, right? In various places across the India, we have the habit to call a particular person by certain nickname, right? It's like in Maharashtra, Tatya, right? Bapu, something like that. So these are the nicknames by which the individuals are identified, right? So these are also the data. This is a personal data. Mobile number is of course personal data, but doesn't stop it there. You will wonder to know that your IP address is also our personal data, right? Our digital habits sometimes becomes our personal data. So if you are searching continuously for certain type of food, so somebody may like very sweet food, right? Somebody may be looking for the non-veg kind of food, right? So that analysis is now getting done through your IP addresses, through cookies, right? So they are analyzing, they are profiling what is your likes, what is your dislikes. So all that is going to be called as personal data. And right now, if you are watching the news, there are latest technologies which can identify a particular human beings by the heat related signals, individual bodies heat related signals. Now, I hope you must be watching certain news. Weapons are used to identify with some sensors individual's body heat. That is not actually covered in this ad, by the way, but in future, these kind of an, you know, the signals by with sensors that could be also come under these provisions of this ad. That is what is expected. And all this data, when it is going to be digitalized, so what happens when you go to the bank, when you go to the hospital, so or even when you go to the any shop, what they do, they ask you, what is your name? What is your date of birth? What is your mobile number? They punch it in the system, in the data, in the computer. So the moment they are doing that, what is they are doing? They are converting your personal data into the digital personal data. At our office also, as a practicing chartered accountancy firm, what we do, we ask the client all these details. And the moment he tells us, we create the master that's in our system or in accounting software or in taxation software. So what we are doing, we are converting the personal data into the digitalized platforms that becomes the digital personal data. And the protection of that digital personal data, that is what is Act is talking about. Concept, we need to understand certain concept, as I said. So there are certain concepts, there are certain provisions, what is the data breach and all these things we need to understand here. So the very basic concept that has been brought forward by this act is the data principle. So here's the data principle, you and me, every customer, every client, every individual for that purpose. That is known as a data principle. So for a chartered accountants, practicing chartered accountant firm, the client is a data principle. When somebody is getting admitted in the hospital, the patient is a data principle. When somebody is visiting the shop, the customer is a data principle. So every individual, every citizen of this India, they are now called as under this act for the provision of compliances purpose of this act as a data principle. Of course, they include the childs, they include the persons with certain disability. But in case of a child, since there are minors, who is going to take the actions for the compliance, ensuring of the compliances for giving certain consent, will act on behalf of this child or on behalf of this person with a disabled kind of things. So Act mentions that for a child, their parent or their lawful guardian could be act as a data principle. The person with the disability, for them also, the lawful guardian could act as a data principle. So every individual human being has been given a status of a data principle. And why it is important? Because with this data principle, they have given certain rights which are very important and very fundamental to protect the digital data. So the concept needs to be very clear. Who is the data fiduciary? The person, the entity. Here it's person, it's not individual, it's person. Person includes all that, the definition which comes under the Income Tax Act, like that. All those entities also getting covered. Legal entities are also getting covered here. So persons includes all those legal entities plus individuals who are collecting the data, who are processing the data in the digital form. So of course, all the banks, all the insurance companies, all the stockbrokers, shopkeepers, all the chartered accountancy firms, all of them becomes the data fiduciary because they collect the data, they collect the personal data, and they process the personal data for various purposes. So all those entities becomes the data fiduciary. So this is the second concept. Now as I said, we collect a lot of data like name, PAN, Aadhaar, mobile numbers, and other financial data. Of course, for our professional services, accounting services, tax services. So we may be classified here as a data fiduciary. Then there is one more concept, that is data processor. So who is a data processor? So it becomes a third party. Who is the data processor? It is actually the third party who is processing the data on behalf of the fiduciary. So let us say your accounting software is in the cloud, right? You don't have any localized environment for that particular accounting software. So that cloud service provider becomes the data processor because all the details are getting legitimately processed in their environment, in their cloud environment. So they become the data processor. Let us say in certain cases, like for the insurance companies, when we go for the health insurance purposes, basically, there are the third party administration. We call it as a TPA, right, who manages various types of the services for the health insurance. So the insurance companies typically provide the data to the TPA. So the TPA becomes the data processor. In case of banks, if you see the whatever be the digital channels services the banks are providing to the customers, they are using the services of various third-party service providers, like the switch vendors, who is processing the data related to the debit cards or credit cards. Or there are certain, let us say the bank has outsourced its check printing facility. So what the bank is doing, bank is sharing the individual customers' data to that check printing vendors. So that check printing vendors becomes the data process. So this is a three-line concept, principally sharing the data to the data fiduciary. And data fiduciary is sharing that data for certain processing purposes to the third person, that is known as a data processor. Right? So this is a three-tier kind of a structure which has been considered under this act. But what is data processing here? Because we need to understand when we call it as a data processing, it could be the backward and forward. Both ways the processing can happen. What is backward and forward? So for collection of the data, let us say there is a marketing agency who is collecting a lot of data for the survey purposes on behalf of certain entity. Right? So actually before using that data into the system, they are collecting a lot of data through the survey. That is the marketing agency's work. So they are acting as a data processor for collection of that data. Subsequently, any organization at the back end may be given that data to any third party for certain further processing. That could be the backward integration. So data processing could happen at the forward integration level or at the backward integration level, anyway. So any collection of the data, that is also data processing. Recording of the data, that is also data processing. Structuring of the data, that is also data processing. Storage, of course, that is a data processing. So what is the data process? Because when we say that to whom we are going to share the data, that is going to be called as a data processor. But in the data processor, who is coming into, if they are playing any of these roles, which is there in my PPT, collection, recording, structuring, adoption, use, alignment, indexing, Even in case when we get the SMS for the banking transaction, bank has to share the numbers to that SMS vendor. So that SMS vendor is also become the data processor. So now you can imagine how the scope is widely covered under this act. So it is covering every step where the data is traveled, transferred, transmitted, and used for various purposes. Within this three-tier structure, they have covered all these things. So data processing covers all the stages, and we need, because when we say that we are looking for the opportunity, because some of our client to whom the data is getting shared, or the auditors for whom we are doing the audit, they may fall either in the category of a data processor or the data fiduciary. So, or some entities would be there, they will have the both roles to play, the data processor and the data fiduciary. Please understand that. We as a chartered accountant may also come under the both the category as a data fiduciary as well as a data processor. How and how? I will just tell to you. So what is a personal, what is the crux of this act? What is that offense which is defined under this act? So the crux or the offense which is defined under this act is the personal data breach. Right? So what is personal data breach? What is that offense? Of course, I'm not mentioning here any section because this is not a typical kind of a legal presentation. If that would have been there is a legal presentation, I would have certainly mentioned the sections and the rules and all that. But I have tried to avoid these sections and all these things. So what is the personal data breach? So personal data breach means any unauthorized processing of personal data. What does that means? So the shopkeeper has collected the data for billing purposes. I have shared my personal data, I have shared my name, I have shared my mobile number, I have shared my address. And shopkeeper is telling me that I'm going to only use for the billing purpose. That's fine. But the moment he's going to share that data for the advertisement purposes, or he himself is going to use that data to SMS me the advertisement, he's not supposed to do that. That is an unauthorized process because I have not given the consent for that. So the purpose, when I am saying that if you go to the objectives I have discussed, in the objective they were very clear that it should be used for the lawful purposes. Number one, the purposes should be very clear. Why we are collecting the data? Tell the client, tell the customer, tell the data principal. That is what they have the right to know about that. And not only that, we have to take the consent from that. Again, I'm going to explain. So, but we as a chartered accountant or our clients, they should also know that for what purposes, or every entity in this process, they should know why I am collecting the data. Which are those processes I am going to, follow by this data. And only for those purposes, the data needs to be used. If you want to do something else, then again you have to take the consent. Otherwise, it could be the unauthorized processing of the personal data. This is the one thing. Second, accidental disclosure. And this is very important because now they are not talking about here intentions, because sometimes it may happen that somebody will intentionally share the data by accepting some amount and so and so. But at some places it may happen with accidental things. For an example, let's take this is a challenge for the chartered accountants. How this may happen that we are sharing our data of our clients' data to our staff. Let's say, take a simple example. We are sharing the data for processing purposes to my staff. By what mode we are sharing that data? That is very important. Sometimes we share that data on their personal email. Sometimes we share that data on the pen drive, on the USB drive. We don't have any intention to disclosure that. Please understand the circumstances, how the circumstances becomes here. We don't have any intention to disclose that. But unfortunately, our staff, because of his negligence or whatever, that USB dropped somewhere, lost somewhere, or the personal emails of them hacked and the data disclosed. What is going to happen? That is not an intentional part on our side, but it is an accidental disclosure. So accidental disclosure is also treated as a personal data breach. Of course, there is a methods by which we have to disclose and all these things. We have to send the notices to our customers and clients. But what is happening there? We may be able to ensure the compliances of further breach. But the thing is that here it is a reputational risk. The thing is that our client or customer will come to know that we are not taking appropriate measures to safety and safeguard of our personal data. That could happen by anyone. So whether it is a hospital, whether it is a shopkeeper, all of them. Now they have to protect their data from these circumstances like the accidental disclosure. So the operational things, how we are handling the data, that itself is a challenge. Acquisition, sharing, use, alteration, or destruction. Everything will be done only with the consent of the data principal. For how much time I am going to use the data? After my purpose is achieved by using that data, what should I do with that data? Even now the data personal has a right to request us to delete that data, of course, subject to the certain other legal consideration. But if we don't do that, that may be treated as a personal data breach. Loss of access to the personal data, when that will happen? Of course, when we are not protecting the system. Suppose there is a ransomware attack. Suppose we are availing, as a chartered accountancy firms, we are making the facility of portal to our clients and they are accessing certain data from there. There are lots of websites which are giving access to the personal data through the website, through the portal. If the person is not going to get that access through that portal, that could be also treated as a personal data. So the CIA principle, that is a crux of the security, that is confidentiality, integrity, and availability of the data. If that is compromised at the data fiduciary level, at the data processor level, then it could be treated as an offense, as a personal data breach, right? And then there could be the process to what to do if the breach would be there and all these things are there. But that is going to impact on us. The next question, to whom this data are applicable? As I said, this is applicable to all the Indian citizens across the territory of India, that is first. Even the data related to the Indian citizen outside the territory of India, that is also applicable. So within India, outside India, for all the digital personal data of Indian citizen, that is applicable. So it is very clear. What is the meaning of that? Of course, now we have discussed so many things that whatever be the data going to be shared within India for various purposes, for that, this act is, but we are sharing a lot of data on certain website. The websites are getting operated. The websites or their companies are incorporated not in India, but they are working outside India. Now they are also required to make the compliances, to ensure the compliances of this Data Protection Act. So any breach by them also will be covered or governed as per the provisions of this act. So every citizen's data within India and outside India, both way, it is protected, right? Whether we are sharing the data within India, that is also protected. The data which is outside the territory of India, but it is related to the Indian citizen, that is also protected by this act, right? But where this Data Protection Act will not be applicable, of course, there are certain circumstances under which the data is getting shared. So when it is on the family to family kind of and things or friend to friend kind of and things, that is we are calling to the personal relationship. I am sharing this data for the personal relationship. That is for the domestic purpose. So if I'm sharing my data with my friend, with my family, with my relatives, that is not going to be governed under this act. Otherwise, there will be a lot of issues, right? So any personal sharing of the data for the personal relationship, that is of course not covered under this act. Personal data that is made publicly available. So if I'm making myself declaring a lot of things into the public domain, for that the act is not applicable, right? So if I'm writing the blog, I have well spread the YouTube. There I have discussed so many things. Contact me. This is my mobile number. This is my email ID. All this. So we are publicly making it available. For that, the act is not going to be applicable for that because that is a voluntary thing, right? Now, what are the data obligations of the data fiduciary? The obligations of the data fiduciary, first and important one, the data which we are collecting or any entity is collecting from their customer, they should understand what is the purpose of that. The purpose should be lawful, number one. The purposes needs to be counted, number two. Only for those purposes for which the consent has been taken from the customer, for that purposes, the data needs to be used, and for that purposes, the consent management is becoming a very, very wider kind of a services. Some of us will think that what is that consent management? It is on the plain paper. It's not like that because consent management does have a total life cycle. What is consent management? So we are taking the consent from every entity has to take the consent from their customer, from their client, who is the data principal. Number one, what is the personal data they are going to handle? Number two, for what purposes it is going to be used? Number three, what is the life cycle of the data? Number four, the client or the data principal, they do have a right to modify the consent, to withdraw the consent, and in case of certain things which is not going as per the consent given, then they do have a right to make a complaint to the data protection board. So all these things needs to be clearly mentioned in the consent. Now, what is happening with this? The consent is not a one-time activity. The data principal can modify the consent, can withdraw the consent. And for that purpose, they have given a lot of rights under this act. And that all the things, whatever is happening, right from the issuing of the notice, accepting the consent, modification of the consent, withdrawal of the consent, it is a life cycle. It is going to happen continuously. Every track of all these things needs to be stored for the audit purposes. So if somebody challenges the thing that I have given the consent, subsequently I have modified that, so the data fiduciary should be able to make a track of it. So it is not possible. If it is a small size firm, it is a small size entity, then it could be handling very few customers, let's say up to 10, 50. Then it may be possible that they can handle manually, but others, it is not possible to manage this without a tool. And let me tell you here that now in the market, there are a lot of companies which are coming to various entities and they are saying that we are having a software that manages this consent. But please note that when these rules are enacted in November, it is clearly mentioned that who can be the consent manager. The consent manager could be the person who is empaneled with that data protection board, who is approved by that data protection board. And there are certain terms and conditions by which the companies can make themselves approved with this data protection board as a consent manager. And those consent manager, they only will provide all this mechanism for this consent management. So right now we should not get into the trap that whoever is coming and approaching and they are disclosing that we are the consent manager. First question we have to ask whether your company is approved by the data protection board. By the way, the data protection board is not yet set. And there is a timeline given for this all the things to be get settled. right? Every entity, they are getting a time of 1.5 year, 18 months from the November. So every entity has to make the compliances of the provisions of this act up to the May 27th. The board, the data protection board may will get set by this coming July, August, or September somewhere. Then they will start approving this consent management and all these things. And then the real things will start about issuing the notices, fixing the role of this consent manager, and all these things. Right? So the data fiduciary has to be very have a clarity about that. The consent, as I said, it should be it should be very specific, it should be unconditional, it should be possibly in the Marathi or in any other local languages, Hindi and English languages, and all these things. So all these things should be there. So state-wise languages, Hindi or English, because ultimately the data principal should understand that. That is the main
Sir,
objective.
sorry to interrupt you. I request you to please, now we have to 10 minutes only to sum up the today's webinar on this digital protection, because in next 10 minutes we are going to take the questions from the participants.
Okay,
Thank you,
thanks.
sir.
Thanks, Mohit. Thanks for that reminder. So the consent should be very free. It needs to be signed, and all the record needs to be kept intact. Now, as Mohit has rightly interrupted me to finish these things within 10 minutes, now instead of going for other things, let us understand what could be the impact or the things which is going to happen with this act on chartered accountant per se. So as I said, the chartered accountant will become whether it's practice, I'm talking about those chartered accountants who are in practice, they will be get covered as a data fiduciary. So they have to make a compliance, ensure the compliances about the obligations of the data fiduciary. They have to obtain the consent from their customers about the purposes for which they are going to use that data. Second thing is that our audit clients are going to share the data with us. So for that, we may be under the category of data processor. So equally, it is important to protect the data which the auditees are going to share with us. The most of the chartered accountants are now understanding the impact of this act, because in various banks now they are not allowing the chartered accountants to take any data on the chartered accountant's laptop or even in other email also. What they're expecting, they are expecting to conduct the audit in their environment. So same could be the story, right? So the clients may expect us to do the audit in their environment. And of course, when that's going to happen, there could be some of the impacts when we are ensuring the compliances with the auditing standards. Of course, all these things, the written SOPs, whether how the client is going to share the data, how the data safeguards are, adopted by the clients, how they are going to adopt these data safeguards when they are sharing the data with the chartered accountants, right? So all these things are going to be impacted. And in that environment, now we will have to do the audit. So all these things needs to be written with an SOP, and all these things should be getting shared with each other. And if the audit is anyways going to give us the data, or any of the client is going to give us the data, then we have to safeguard that. We have to carefully handle operationally also that data. So the challenges could be that we have to implement and ensure the compliances of this Data Protection Act, whatever be the provisions for that. For that purposes, as a CFM, we need to ensure what are those various requirements for which we are collecting the data from our client. We have to think about how we are going to handle about this notice and consent management from our clients. If the firm is very small, they can handle with in-house kind of an operations, or if the firm is handling quite a number of clients, then they have to think whether that notice and consent, because don't assume that it is a very simple task, because client may do anything at whatever, and they have given the rights. The data principles has given the right, various rights under this act. So they can modify, they can withdraw, they can have a right to correct, they can have a right to delete. All these things are there. And for every purposes, we have to keep a track of all these consents. So one has to think about, as a chartered accountancy firm, whether this notice and consent management could be managed within our office or needs to be outsourced with that approved consent management team. Then we need to ensure about how we are actually using the personal data, digital personal data of our clients. The tracking of that is very, very important. Because as I said, if we are going to use the data, the client has given the consent only for the taxation purposes, only for the income tax purposes, then we need to use and we have to ensure that that is only going to be used for the income tax purposes and not for any other purposes. Of course, the technical measures like the encryption of the data, masking of the data, and it is not again an easy thing, because when we are saying about the encryption of the data or masking of the data, the compatibility of our software is again a challenge. So we need to test all these things. Of course, we are having this 18 months period. I mean, up to the May 27, we have enough time to test. And of course, the vendors will visit us. They will say that our software is ready with all these, technical things, but we need to adapt for that. Of course, operational measures. Now, our habits, how we are sharing the client's data to our staff, whether on the personal email, on the USB. So all these were operational measures and what they are doing with that data, the controls, operational controls also needs to be kept intact. So these are the challenges when we are saying, so sharing of the digital personal data with the cloud environment, with the other parties, from where we are taking the various types of the services for the software kind of things. There we have to see that we have to ensure, we have to obtain the consent from the client that we are collecting the data, but the data is going to be shared with the third party data processor, and the name and the details of that third party data processor needs to be mentioned in that consent. Whenever there will be the change in that third party processor, again the new things will come up and the new consent needs to be obtained from our clients. And of course, we have to set up a complaint management process also. So if the customer do have any complaints about his or her personal data, then we should have the management process for that. Where are the opportunities? Lots of opportunities. Data audit is coming up because there is a third party and independent verification of the compliances of these provisions of this act is mandated for the significant data fiduciary under this act. So audit of the data protection to ensure the compliances of this provision, that is the first opportunity. Advisory for the compliances under this environment. But for that purposes, as I said, don't feel that it is only the operational or only the legal compliances, because it's a technical matter also, because it requires a lot of things in the consent management. It requires a lot of things to be treated for the data life cycle. Something technically needs to be adopted for the protection of the data, as I said, in the case of encryption or the data masking or any other measures which they have today, and the compatibility of that and the practices, digital practices which they are following. Then a lot of things will be there when the website will be there. What about cookies? What the data is going to be collected under the cookies? What is the consent? How the consent is, consent means, if you know that when you operate any website, the website asks you to give the consent to the cookies by reading the terms and condition. Many of the times we don't read that terms and condition. But what is that cookies? How the setting is done? What kind of a data is going to be collected under the cookies? How the life cycle of that data which is collected under the cookies is going to happen? That the same thing would be there for the mobile app. Lot of things we give access to with this mobile app. You know that even we give the access to our photos, pictures, and contacts and all these things. So if we are at the other side as a consultant or as an advisor for the clients who is having that mobile apps and all these things, so there also I think we'll have a lot of opportunities to provide a technical advisory, I can say here. And for that purposes, I think we need to upskill ourselves with this certification, which is, of course, the ICI is coming up with this DPDP related certification course for that. So one should have the skill set, upgraded skill set with that kind of an certification kind of a thing, which will provide you this opportunity. So Mohit, as I said, right on the time, I have stopped. Now it's open to you for the question. Mohit, are you there?
Thank you so much, sir, for your Thank you so much, sir, for your knowledgeable knowledge thing that have been shared by our respected members. Now I am taking the questions one by one from Anil Batraji is asking from New Delhi how to restrain unauthorized access to your personal data.
Can you please repeat the question?
How to restrain unauthorized access to your personal data.
So that's why I said there are when you are sharing the personal data with various entities, the first thing is that they will obtain the consent from you that for what purposes they are going to use that data. Afterwards, if you want to know that how that data is particularly used by those companies or by those legal entities, you have now given the right to ask them or to give them. You can ask them, you can request them to provide the details by how the data is used. So if the data is used by, beyond the whatever the consent you are given, so that information will come to you, and that's how you can restrict the access only for the consent related things. So that is one way to get the knowledge about that. Yes, Mohit, any next question?
So thank you so much, sir, for your deliberation on this question. E.A. Ravi Kumar from Bangalore is asking the question, but his question is not clear. Sir, can you please write down your question again? From E.A. Ravi Kumar ji from Bangalore, please write down your question again. Now I'm coming to the question from V. Namesh from Bangalore is asking a question. Does iris scan thumb impression also comes under the primary definition of data? If so, how does the security of the same is ensured by the collector or data processor?
Yes, so the thumb impression is a digital personal data, of course. The whoever is collecting that thumb impression now, for what purposes the thumb impression is going to be collected, that needs to be very clear. And how the safeguard is taking to protect the data wherever that thumb impression is going to be stored. Because as I said, when you are giving the thumb impression, if they are validating that with the Aadhaar kind of and things, then there is a separate audit is required for that Aadhaar enabled services. That is one more type of the audit. That is a purely the security audit which that organization has to comply with that. Second thing, if it is not related to the Aadhaar, but still they are collecting the thumb impression for any other purposes, but they are not comparing with that Aadhaar, then the questions would be, of course, that how safely they are storing with, and only for the purposes for which that is been given, only for that purposes the thumb impression is going to be utilized. Of course, the data principal, who is the client or customer, they do have a right to take this information. They can make the request under this act to the entity to which they have shared that thumb impression. First, before giving the thumb impression, they will have to take the consent from that customer, that why they are collecting the thumb impression, for what purposes they are going to use that thumb impression, and then the giver, the customer or the client, they will give the consent number. That is the process. Once they have given the consent, they have given the thumb impression. Afterwards also, they can inquire that the right has given to this data principal to inquire about how that data of the thumb impression is actually going to be used. And that's what I said, that consent and all the track of usage of the data that must be kept by the data fiduciary. Yes, Mohit.
Thank you, sir. Now next question is going to be asked by Radhika Pandey from Gurgaon, seeking assistance on ChatGPT on any issue without taking name. Is it covered?
Basically, I would like to give the cautions here that without the consent of any client or customer, we cannot submit the data of any of the customer or client on any of the cloud platform, whether it be the artificial intelligence or whether it could be any open website. So the first thing, if you want to use that data on any AI platforms, whether it could be any AI platforms, you should have the written consent from that particular client. Otherwise, that could be the unauthorized usage of the client's data, and it is not allowed, as we have seen that it is comes under the personal data breach. So, using the data on any artificial intelligence platform without the consent could be a personal data breach.
Sir, E.A. Ravi Kumar from Bangalore has again mentioned his question. Resident Welfare Association conduct general body meeting and members sign the attendance. The name and flat number of the member also goes into the minutes of meeting and posted on WhatsApp owners group. What precautions should the Resident Welfare Association take to safeguard their interest?
Yes. So Ravi Kumarji, in this case, now there are still 18 months to go to ensure the compliances. The process has been started by the enactment of the rules in November 25. Yet the data protection board has to be set up, and then the approval of the consent manager and all these things will go on. May 27 is the deadline by which every entity has to ensure the compliances, right? So within that time, as an organization, what you can do, what data is getting collected, for what purposes that is getting collected, make an inventory of that, and ensure that what kind of data is really required for the your purposes. The data which is not required for your purposes, then please don't collect that data. And after the data protection board will be set up, then you will come to know who are the approved consent manager. Because as I said, it's lengthy processes and it requires a lot of data, I mean logs and trails and documentation to be kept related to the consent, because a lot of things is going to happen with this consent. So please ensure that the services of the consent manager that is required. If your organization is very small, then you can handle that in-house. But if the number of members are very large, then you have to take the help of the consent manager. Where you are storing the data, on what digital platform you are storing the data, the protection of that data, encryption of that data, masking of that data, available that data only to the authorized person. So access control. So all these are the technical measures which your organization has to ensure to protect the members' personal data. Yes, Mohit,
Thank you,
next.
sir. Next question is going to be asked by the Dharmendra Kapoor from Kolkata, whether CA firm will be a data fiduciary or data processor.
As I made it very clear, the chartered accountancy firm, when they are providing certain types of the services, they will act as a data producer. Let's say you are providing the services related to accounting, taxation, where we are collecting a lot of data from our clients. So in that case, we are going to act as a data fiduciary. But at the same time, when the auditees are going to share their data with us for the audit purposes, in that capacity, we are going to be act as an data processors. So chartered accountants will come under the both the ways depending upon what type of the services they are providing.
Sir, Varun Agarwal ji from Chennai is asking, sir, under personal data breach, you mentioned about shopkeeper collecting the data for billing purpose. But if they use for marketing, then it's a data breach. In real life, many of the big retailers like Lifestyle, PVR Cinemas collect the data for billing and sending, and then they send the promotional SMS. Is this a data breach?
Yes, that's the example I given, that the purpose, what the purpose is, if they say that my purpose, they are collecting the data only for the billing purposes. So they should use that data only for the billing purposes. The moment they are trying to send you the SMS related to the advertisement purposes, that is not authorized, that is the consent you are not giving for that purposes. So that could be the personal data breach. But as I said right now, even though that is a personal data breach, there are other measures by which you can take the action. But if you want to take the action under this Data Protection Act, then we have to yet to wait, because the Data Protection Board is not yet set up. It will be get set up, as I said, within this year, and then the whole mechanism of registering the complaint and all these things will take over. And one more thing that reminds me very well, because a lot of companies lot of companies, you can see the NBFCs, they are giving you the one or other day the call on the mobile phones for the loan facilities and all that. That is their marketing strategy, but that is going to be affected on a large scale basis because of this Digital Personal Data Breach Protection Act, right?
Sir,
Because
CA Ram Samaria from Mathura is asking the question.
Mhm.
What precautions or measures a CA could suggest for school ESP? I think ERP होगा. ERP,
Mhm.
where student personal data and teachers data are on ERP for fees or payroll, etc. purposes. Means how data protection services be rendered by a CA to schools.
There are certain exemptions, Mohit, which are given under the rules for the schools and the staff related data. That provision is there, and exemptions are mentioned in the rules. Because of the time restrictions, we are unable to explain that exemptions. But The schools are exempted for the collection of the data and the processing of that without the consent and all these things. But that should be only for the schooling purposes, and they should not use it for any other purposes. But the exemption is there under Section 7 and all these things that is well covered under the rules. If we'll get another chance, we will discuss those in details. Yes, Mohit, next question, please.
Sir, V. Ramesh from Bangalore is asking the question: do you feel that consent manager needless be an agency like UDAI or even private parties? What may be the risk we may perceive?
So the consent management, as I said, those agencies would be approved by the Data Protection Board. It is not any private agency. I mean, not any agency. It could be the private company, but it needs to be approved by the Data Protection Board. So when we are availing the services of the consent manager, we have to ensure that those consent managers are approved by the Data Protection Board. That is one thing. And they will also in a way become the data processor, so they have to also ensure all these clauses or the provisions of this act. So we have to, and that will be of course ensured by this Data Protection Board also within their processes. Yes, please,
Next
next question.
question is asked by Vibha from Ahmedabad. She's saying, nice session, sir. Do we have any software for consent management or tracking the data used?
Yes, as I said, for the consent management, as I said, the consent manager itself will bring the software. Lots of companies are now marketing their softwares, but we have to be very careful because we have to get that consent management services only from the approved consent manager who are approved by the Data Protection Board. And as I said, Data Protection Board has not yet set. And there is, of course, in absence of the Data Protection Board, there is no question of approved consent manager kind of a thing. So we have to wait for those approved vendors, and then we can have a choice to select X or Y kind of an software for that purposes.
Sir, CA Radhika Pandey from Gurgaon is asking the question. In case of staffing company, all details of employees employed by client are maintained. What precaution and compliance is needed by a staff agency?
If it is a processing, I mean outsource kind of a thing, then there is a data processor's role will enact. But as far as within the company, let us say employer-employee relationship are there and all the records of the employees are maintained by the employee in-house, then as I said, there are certain exemptions given under the rules. So those exemptions will be get affected there. But if the employer is outsourcing the total payroll processing to the outsourced vendor as a third party, then they will become the data processor and they will have to take certain measures to ensure the compliances of this act.
Sir, Rohit Nagarat from Hospet is asking the question, what are the penalty provisions?
Penalty, it's better not to discuss here, but let me tell you that of course the Data Protection Board will all do all the proceedings and all that, but it starts from 250 crores, of course, on the basis of the scale and whatever they will decide the penalty, but it's 250 crores and it's going on that way. So it's not affordable in a way.
K. Swaminathan from Madurai is asking the question. Madurai is asking the question. Data shared already, then how it will be protected?
Whatever be the data already shared for them also, the Data Protection Act says that even though I have given the data already with my bankers, with my insurance companies, for that also now they have to take the consent, a new consent from us for the purposes and utilization of that. So even though I have already shared the data, they have to take the consent. And if they have not taken the consent and without the consent, if they start using the consent, that could attract the provisions of the personal data breach.
Yes, thank you so much, sir. That's all about. Sir, one more question is coming from Nitin Vaidya from Mumbai. It's a last question. For in-house consent management, any approval required by the board?
No, only thing is that all the documentation, all the tracks about the consent management has to be preserved. And in case of some complaints or some issues raised by the customer about the consent and all these things, then the in-house department should be able to produce that kind of documentations or the trails and whatever. So it depends upon how the in-house department is capable in handling the total data lifecycle number one and the consent management lifecycle number two. So if they are enabled enough to do that, then I think there will be no requirement of the outsource consent manager, but that department should be self-sufficient for these purposes.
Sir, that's all about of the day. On behalf of CP committee of ICI and on behalf of entire participants on this 85th webinar that have been conducted, and wherever you have served this fraternity as a speaker on this most hottest topic of the this era, I can say, this digital environment, this digital India, on this Digital Protection Act 2023. You have covered. We know that due to the time restrictness, we have not been covered whole kind of the thing, but you have shared your immense knowledge to our participant for upgraded their self for their knowledge based skill level. Thank you so much, sir, on the behalf of CPE committee of NRC ICI for giving your valuable time to our fraternity for on this evening of 85th webinar. Thank you, sir. Thank you, Uday, sir.
Thank you,
Now
all the
I'm requesting.
participants. Thank you, Mohit.
Thank you so much, sir. Now I'm requesting to all the participants of our fraternity of the chartered accountants that India is going to, our ICI is going to again host BOFA 2.0 on 30th January to 1st of February at India Expo Mart, Greater Noida. All are requested to please go and register yourself and become the part of this BOFA 2.0, where we are going to expand our networking, we are going to learn, we are going to expand our horizon of the learning, meeting the new people, getting the professional opportunity, listening about the speakers from the India as well as abroad, where we are having the gala nights and the evening. We are going to celebrate with the cultural evening event where a lot of the culture artists are coming and perform their skills over there. And hope we are going to meet at India Expo Mart, Greater Noida from 30th January to 1st of February. You may avail that 2000 rupees concession by 15th of January. That is a tomorrow is the last day by applying the code WOFA 2000. So you may go and register yourself if you have not done. If you have registered, then let's meet at Greater Noida India Expo Mart from 30th January to 1st of February. Don't forget to carry your cards and the knowledge that we are going to share with our fraternity members. Now it's a time to let's start our next topic with in new labor code. New labor code is the emerging area where mostly of the chartered accountants are not practicing. But yes, our ICI taken care of, our CPE committees taken care of the new avenues, new horizons, so that from the new things we can earn and learn new avenue skills. Now let's welcome our speaker of this evening of this 85th webinar, CA Chetan Agarwal. Now let me introduce our speaker of the day. CA Chetan Agarwal is a qualified chartered accountant and member of ICI with graduation and post-graduation from Rajasthan University and has a 4 years of specialized experience as a labor law consultant. He is having a strong experience in Indian labor legislation, including the Industrial Disputes Act, Shop and Establishment Act, Factories Act, Contract Labor Act, and the new labor code and social security laws. And he has played a key role in labor laws audit for major corporate and non-corporate clients. He advises the organization on labor law compliances, HR policy drafting, statutory register, and returns and represent employer during labor inspection and proceedings, ensuring the practical and risk mitigated compliance solutions. He is also actively involved in training students and professionals on labor laws and payroll compliance with a focus on simplifying complex legal provision and their real world application. With this, it's not a brief personality with a huge experience, but due to time restrictness, I've introduced in a brief. Now let's welcome to our next speaker of the day, CA Chetan Agarwal. On behalf of CPE Committee of ICI, on behalf of our chairman, CA Satish Kumar Gupta ji, CA Vishnu Kumar Agarwal ji, Vice Chairman of the committee, I welcome CA Chetan Agarwal ji to take the webinar or the new heights by taking the second topic of the today's evening of the 85th webinar on new labor code compliances. I request all the participants stay tuned with the topic and requesting you may ask the question by mentioning your question and that will be take up in last 10 minutes of the session. Sir, you are requested to please take up the session. Thank you, sir.
Thank you, Mohit ji. First of all, I want to express my sincere thanks to CP committee, Satish sir, Vishnu sir, Mohit ji, and of course, audience. So today our topic is on India's new labor code. It's visible.
Yes, sir. Visual. Please go ahead. Please go ahead, sir.
Thanks. So we all know that on 21st of November 2025, the Ministry of Labor and Employment has announced that 4 new labor code has been implemented immediately. Okay, that is on 21st November only. So these new labor codes are actually enacted, or we can say that drafted very earlier, that is on 2019 and 20. Actually one code is drafted in 2019 and remaining 3 codes are drafted in 2020, but due to many reasons, we can say political or other reasons, the government did not implement it. Finally, on 21st of November, these 4 labor codes, yes, these codes has been implemented with immediate effect. Okay, the codes are the Code on Wages 2019, the Industrial Relation Code 2020, the Code on Social Security, and Occupational Safety, Health and Working Condition Code 2020. Okay, so first of all, we will see that what are these code and what law has been repealed, or many law, what law has been merged in these 4 codes. Actually, these 4 labor codes are enacted by repealing, or we can say by merging 29 existing central laws. If we talk about the Code on Wages, the Code on Wages has been enacted by merging or repealing the Payment of Wages Act, the Bonus Act, Minimum Wages Act. Okay, and if we talk about the Code on Social Security, there are approx 9 acts, existing acts like KPF, gratuity, ESI. If we talk about Industrial Relation Code, the Trade Union Act, Industrial Dispute Act, Standing Order. If we talk about Occupational Safety, Health and Working Condition Code, there are many acts such as Factories Act, Contract Labor Act, BOCW, BD and Cigar Act, Cine Workers Act. So there are total 29 existing law, and which these existing law has been merged in only new 4 labor codes. So from now we will only discuss, or we will only apply these new labor codes. Since the rules supporting these 4 new codes has not yet been finalized or not yet been implemented, so if there are any difficulty arises, we are following, of course, existing law as well as new labor codes. This is the implementation timeline. Actually, 29 existing law consolidated in 4 acts. These are only central acts, not state acts. In August 29, the Code on Wages was enacted, and in 2020, the remaining 3 code has been enacted, and ultimately on 21st of November, the 4 codes has been implemented. Okay, so first of all, we will discuss about the Code on Wages provisions and what has been changed and what new provisions has to be followed by an employer, by industry. Very initially, the new labor codes, or we can say the Code on Wages, has a provision of universal minimum wages. If we talk about pre-labor code scenario, so the power of issuing minimum wages is with state government. Actually, the term labor is all about concurrent list due to state and central both have parliamentary rights to enact any law. So the minimum wages, the power to issue minimum wages is with only state government. But in new labor code, the central government propose a universal minimum wages. We can say floor wages, or we can say national minimum wages. The government will issue, central government will issue a minimum wages, for example, the central government has issued minimum wages of 15,000. So every state government has to follow this minimum wages, and state government cannot fix their state minimum wages below that level. Okay, so this will be a very impactful change for industry, or of course for employers, just because if we talk about Rajasthan, there are very low minimum wages, like less than 10,000 for skilled workers. However, in some state, like in south states, Kerala, Karnataka, there are very good minimum wages, which is above 15,000. In MP, approx 12 to 14,000. In Gujarat, 12 to 14,000. But there is no uniformity as yet. Now the government will the government will unify this minimum wages, and of course still the power to issue minimum wages is with only state government. Actually, state government will issue the minimum wages in their state, but the government, of course state government, will issue minimum wages and cannot fix minimum wages below that level which has been issued by central government. So the first change is on universal minimum wages. The second change on payment of wages. If we talk about existing system or pre labor code scenario, there are two time limit of payment of wages, which is 7th or 10th. If the employee size of organization is up to 1,000, the employer need to pay on or before 7th of next month wages to all employees. And if the employee size is above 1,000, then employer need to pay on or before 10th of next month. Okay, and if there was any holiday, so employer need to pay on 9th or 8th or whatever. But in any situation, employer cannot go beyond 7th or 10th. In new labor codes, the time limit of 10th was removed. There is only one time limit. All the employer need to pay wage to their employees on or before 7th of next month, if the employer is paying wages on monthly basis. And of course, there are other time limit also has been added in new labor code. If the employer is paying wages on daily basis, then as per new labor code, as per new code on wages, the employer need to pay wages to employees on at the end of that day only. So if the employer is paying on daily basis, employer cannot pay on next day the wage to employee. He has to pay on at the end of that day only. If the employer is paying wage on weekly basis, then employer need to pay at the end of week, at the end of the day, and that at the end of the day also which day should be the working day. For example, if the employer is paying the wage for Monday to Saturday, for example, there is a 6-day week. Okay, so the employer need to pay on Saturday only. He cannot pay on Sunday. Okay, and if the employer has a 5-day week policy, then the employer need to pay on Friday only. So for daily payment, the employer need to pay at the end of that day, and for weekly payment, the employer need to pay at the end of the week. And of course, that day should be working day. Next, if the employer is paying on fortnightly, like 2 times in a month for every 15 days, then employer need to pay salary within 2 days from the end of that period of 15 days, like for first to 15. For example, if the employee is paying salary or wage for first to 15th, then employer need to pay on or before 17, and for 15 to 16 to 30 or 31st, on or before 2nd of next month. So these time limit has also been clarified in new labor code, that is the code on wages 2019. Also, there is one more time limit which has been clarified in new labor code. Earlier, if we talk about payment of wages act, so there was a provision that if any employee is retrenched or terminated, not resignated. Okay, we are talking about retrenchment or termination. Then employer need to clear their dues within 2 working days from the date of termination or retrenchment. So earlier, if there was any termination or retrenchment, then employer need to pay within 2 working days all their due. But in the new labor code, the term resignation has also been added in this list. And now, if the employee is terminated, employee is retrenched, or even employee is resignated, like employee gave resignation, still the employer need to pay within 2 working days. And of course, employer need to clear all their due within 2 working days. So these payment time limit has also been added or clarified in the code on wages 2019. Next new provision is for equal pay for equal work. Actually, in new labor codes, of course, in all 4 codes, there are many terms added, such as fixed term employees. Fixed term employees means any employees hired for a particular period, and which is, of course, which is clearly mentioned in their appointment letter, and which is fixed. For example, employees hired from 1st of Jan to 31st December 2026. Okay, so these type of category will be called fixed term employees. And we all know that there are other category like contractual worker, contract workers, gig workers. So the new labor code clarify that employer need to pay, or employer need to satisfy all the equal remuneration conditions, such as he has to pay equally to their permanent employees, to their contractual employees, to their fixed term employees. Even he cannot sorry, he cannot distinguish their permanent employees or contractual employees even by dressing sense, even by any other facility provided to employees. Meanwhile, sorry, meaning thereby that all the employees will be treated uh, in same manner, and all the employees will be paid in same manner for their work. So employee cannot pay less than permanent employees to contractual employees or fixed term employees. And of course, there is a new provision of gender discrimination or gender inequalities. Employer also follow all the equal remuneration provisions for genders, all genders, such as he cannot differentiate male and female employees, or he cannot reduce salary or wage of male or female employees through their gender. Even female employees get all the right which are payable or which are provided to male staffs. So equal pay for equal work will be the new provision under the Code on Wages 2019. There are also some provisions such as female staffs or female workers now allowed in night shift working. Actually, earlier the employer need to take approvals from government or concerned authority to work in night shift for all their female employees. Now the government has removed the restriction to take approvals for night shift working of female employees. The government said that the only condition is that the employer need to protect or employer need to arrange the proper security arrangement for female employees, such as installation of CCTV or arranging cab facility, home to office, office to home, so like implementation of post sexual harassment policies properly. So if the employer is following these protections, the employer can freely hire female staff in night shift also. Further, female employees are also allowed in hazardous industry. Earlier, the hazardous industry cannot or not allowed to hire female staff or even children. Now, the government clarified that female can work in hazardous industry. Again, the same condition that the employer or manager need to take proper care of female staff, such as medical facilities, such as proper fencing, proper security arrangements. So employer can hire female staff in hazardous industry also. Next major change under Code on Wages 2019 is that the basic salary has been unified. Earlier, if we talk about pre-labor code scenario, there are no uniformity in salary structure. An employer can fix basic salary 20%, 30%, 40%. I'm talking about previous law. Okay, so under new code, the government clarified that the basic salary should be 50%, at least 50% of their total remuneration. Okay, so we will discuss this in details. That the government has clarified under new labor code that the employer need to fix their basic salary at least 50% through wage definition. The definition of wage is that basic salary plus DA plus retaining allowance should be at least 50%, and the remaining part such as exclusion part, allowances, HRA, other medical facilities provided by employer, other perquisites provided by employer, gratuity, etc. So these exclusion part cannot be more than 50% of their total remuneration. Okay, and if the total the exclusion part is more than 50%, then the remaining part is excess of 50% will be added in basic salary, such as basic plus DA plus retaining allowance. So there are two part in wage definition. The first part is inclusion part. Inclusion part say that the salary will be basic salary, dearness allowances and retaining allowances. And the second part is exclusion part, which is gratuity, retirement benefits, allowances, HRA, and other facilities provided to employer. So, if we talk about private organization, generally DA is not there, so we can say that, or of course, retaining allowances is also not a subject of daily occurrence or in monthly occurrence. So we can say simply that basic should be at least 50%. The impact of this will be on employee or employer, both will impact will affect both employer and employee. For employee, the in-hand salary can be reduced, like earlier, let's suppose the basic salary is 40%, then the PF deduction of employee will be less. And now if basic salary will be 50%, then PF deduction will be high, and the in-hand salary will be a little low for employee side. And of course, employer burden will also increase. Employer have to pay employer part also on high increased basic. Generally, PF is applicable on basic salary. Not only PF, there are many benefits such as PF, bonus, gratuity, etc. All these payments are depends on basic salary. So the basic change in salary structure will impact on employee and of course employer also. So these are the basic compliances under Code on Wages 2019. Of course, there are also some minor changes, but the major changes under Code on Wages 2019 is only these 4 to 5 changes. Now we will discuss about Industrial Relation Code 2020, and we will discuss that what changes has been made through new labor code. First of all, under Industrial Relation Code, the applicability of standing order has been changed. Actually, earlier, if we see that standing order is earlier applicable on an organization having 100 plus employees. Okay, a standing order means that there are specific law or there are specific permission need to be obtained from government or concerned authority for implementation of new policy, for retrenchment, for layoffs, etc. So now the new code clarified that the standing order will be applicable on an organization having 300 plus workers. Okay, so it will affect an organization. For example, if earlier, let's suppose an organization having 200 employees, so earlier the standing order is applicable on that organization, but now the due to Industrial Relation Code, the standing order sorry, is not applicable on that organization due to having less than 300 employees. And what does it affect? Actually, there are many permissions which are required under standing orders by an employer to implement a policy for even closure of an organization. If let's suppose employer is planning to close or voluntary close their organization or retrench their employees or even lay off their employees, then he has to take prior approval. He cannot retrench or he cannot close their organization or their factory without the prior permission of government, if the standing order is applicable. But now if the employer having less than 300 employees, of course he can close or he can do such works which are not required to take prior permission under standing orders. Actually, it doesn't mean that he can directly retrench or he can directly lay off all their employees. No, the procedure has to be followed for such as retrenchment procedures like payment of at least 30 days for 60 days, 90 days payment of wages or prior notice. These requirement will be still followed, but specific permission from government has been reduced for employees or has been eliminated for organization having less than 300 employees. Now, the new term has also been added. We have already discussed the fixed term employee. Actually, fixed term employees already discussed that the employees having fixed tenure. For example, employee hired for a particular period of 11 month, for 12 month, for 15 month, or for a period of 1st of March 2025 to 31st December 2027. So these employee will be called fixed term employees. Now there are many changes for fixed term employees. We will discuss later that the gratuity eligibility has also been changed for fixed term employees. For generally gratuity eligibility is gratuity condition is continuous service of 5 years, but for fixed term employees the eligibility has been reduced by for 1 year only. Also, the fixed term employees will get all the benefits equal to permanent employees or permanent workers. So we can say that there is no difference in fixed term employees and permanent employees. Fixed term employees will get equal payment, fixed term employee will get equal facility, fixed term employee will get equal allowances, equal. Even for example, employer cannot differentiate in dresses also. In some organization, employer provide dresses to their employees, so he cannot provide dresses like low quality dresses to their contractual employees or fixed term employees. So he has to follow all the uniformity between permanent employees or fixed term employees. So these are major changes under Industrial Relation Code. Of course, trade union recognition, negotiating unions must have support at least 51% of workers with negotiating councils for multiple unions. These are the major changes under Industrial Relation Code 2020 by virtue of new labor codes. Now, the Social Security Code 2020. Actually, Social Security Code covers many acts. There are approximately 9 acts in Social Security Code, which are PF Act, ESI Act, Employees Compensation Act, Employment Exchange, Maternity Benefit, Gratuity Act, etc. So the provisions which have been clarified or which has been changed, we will discuss under this new code, which is the code on Social Security. First of all, the government or ministry has issued that ESI registration will be available on voluntary basis now. Actually, earlier, if we talk about existing system or pre-labor reform, so earlier PF registration is available on voluntary basis, but ESI registration is not available. If we when we register our organization on ESI portal. So it will demand that at least there should be at least 10 employees. Now, through new labor code, the government clarified that ESI registration will be available on voluntary basis. And of course, in some organization, the government will announce soon, still not announced, that in some organization which are hazardous in nature, the limit of employees for registering under ESI will be one. That is, even for single employees, the organization need to take registration under ESIC. Existing limit is 10 for ESIC and 20 for PF, and the limit is same in of course new labor code, but for some hazardous industry the government will implement ESI in even for single employees, and of course the voluntary registration has been provided. Further, ESI applicability is existingly vary from state to state. Actually, in some state there are known implementation area. If we talk about Gujarat state, so there are many districts where ESIC is not applicable. In Maharashtra also, in Madhya Pradesh also. So now government has also clarified through new labor codes that the ESIC will be applicable on pan India basis, meaning that the ESIC will be applicable on whole of India, irrespective of the state. And sorry, there is no known implemented area. There will be no known implemented area under ESIC. So ESIC will be now available for all the states, all the districts. Next is maternity benefit. Of course, government has strictly announced that 26 weeks of maternity benefits will be provided by employer to our female staff for as a maternity benefit, as a maternity leave. Earlier, the provision was also there under Maternity Benefits Act, but there was some limitation, such as the act. Now the code will be applied for all the organization having implementation of any of these 9 acts. Earlier the maternity act is applicable on specific organization. Now government clarified that the maternity benefit will be strictly provided to all the female staff for first 2 childs. Okay. Further, also the government has also clarified that the organization having 50 plus workers, then employer have to provide crèches facility for their childs. Okay, so in the organization having 50 and more workers, so the employer will provide the crèches facility to their employees, to their employee childs. Next, there are some clarification issued by ministry that for example, if we talk about crèches facility, organization having 70 employees, let's suppose, is not able to provide crèches facility, so government clarified that he has to pay crèches allowance to their employees, or he can aggregate organizations like in a place where let's suppose 10 employers are working, or 10 or more organization are exist. So these 10 organization can aggregate for facility provided to employees, such as crèches facility, such as a medical facility, etc. So the organizations or employers can aggregate their organizations and can provide facilities to their employees also. So these are the major changes under Code on Social Security. Next, the Occupational Safety, Health and Working Condition Code. So this code mandate many new things, such as firstly, annual health checkup. Under the new code, all the employers are liable to provide at least one annual health checkup to all their employees having age 40 and more. Okay, so now earlier there is a no provision of health checkup, but now all the employees mandatorily have to provide annual health checkup to their employees having 40 and more age group. Okay, and government has also clarified that in any way the employer cannot charge or cannot recover the cost of such annual health checkup from employees. Okay, so it will be the it will be the direct cost of employer only. Further, government also clarified, the code also clarified that in some industry, actually this provision is for only employees having 40 and more years age. In some hazardous industry, the government will later notify that on which organization the provision will be applicable. For some hazardous organization, the government notified that employer will provide annual health checkup, also some mandatorily health examination. Actually, the first provision is for health checkup only, and the second provision we are talking about mandatorily health examination, under which there may be blood pressure test, sugar test, ECG, whatever. Actually, the government will notify soon. For some hazardous industry, that will be provided to all their employees, even without any age restriction. Actually, second provision is for specific industry, for hazardous industries. Okay, so the government will notify that for hazardous industry, not only health checkup but also some medical examination. This will also be notified by government that what type of test the employer need to provide to their employees, and even government will also notify that in what interval the employer will provide the medical examination. For example, if it will depend on the nature of the industry, how and in at what extent the industry is hazardous to employees. It can be, of course, the employer, government can.
Am I audible? Chetan sir, am I audible? Sorry to interrupt you. We have to compile up this topic in next 4 to 5 minutes. And afterwards, we have to take the questions as well from the participants. Thank you, sir. Please.
Oh, thank you. So, for hazardous industry, of course, first provision is for general. And the general provision is applicable for all employers, and the second provision is applicable for hazardous industry. Next is next changes or next clarification is for overtime working. The government is now allowed 12-hour working. Actually, earlier the maximum working hour for a day was 9 hours per a day, with spread 10 and half. Now the government has clarified that the maximum working hour can be 12 hours. But of course, the total weekly hour will be only 48 hours. Earlier, the limit was same. Now also the limit is same, that 48 hour in a week. So meaning that if the employer is following the 12 working hour per day, he can mandatorily off 3 day in a week. So it will not impact the employee just because if he is working more, then he is eligible for 1 day extra leave. Safety standards, of course, in many specific industry like mines, construction sites, there are specific safety provisions for specific industry and as per their nature of work. And actually, the rules supporting these new 4 codes has not yet been finalized. The government issued draft rule on 30th December, and these rule will be finalized in the month of Feb or March. So the government will issue these provisions such as safety standard, annual health checkup provisions, etc. Women's policy, of course, we have already discussed that females are allowed in night shift. Also, females are allowed in the others industry also, and females are eligible for equal pay or equal chances. Even the another provision under new codes are is that employer cannot discriminate by gender, such as employer cannot publish advertisement for recruitment that only male staff is allowed even. So these are the main provisions under occupational safety health working code. What we have to do, immediate action required. Of course, first of all, we have to review our employment record, and we have to update our records as per new labor code provisions, train our HR team, prepare registers, documents, etc. required as per new labor codes or as per other government policy, or of course rules are coming very soon. So there may be high chances that under rules additional documents are also required for an employer to maintain. So this is the major compliances requirement under new labor code. We will discuss in detail. Of course, the time limitation is only for 1 hour. So otherwise, the topic is for 3 hours. Now, if you have any question,
Thank you so much, sir, for your words of wisdom that have been shared with our participant, with our chartered accountant, and a long list of questions are there. First of all, I'll take the first question from Thomas T. Alanical from Kumile, whether the new labor code applicable for small CA firm.
Of course. Earlier, actually, if we talk about the definition, so there is a word establishment. So establishment cover all the establishment, not only commercial establishment. So CA firm is actually all 4 codes are applicable on CA firm also.
Next question is going to be asked by Vibha from Ahmedabad. Does the act applies in case of voluntary sharing of data?
No. It is on discretion of employers or employees. He may share data, but still there is no requirement or there is no mandate to share data.
Sir, CA Ram Samaria from Mathura is asking the question, CA opportunity under DRDP Act.
Actually, government will finalize rules in Feb or March. After that, it will be better clearance that what major opportunity will be available.
Pratap Bora from Bangalore is saying nice session. Thank you, Pratap ji. Radhika Pandey from Gurgaon saying excellent session, sir. Thank you, Radhika ji, on behalf of our faculty. Rohit Nagarat from Hospet is asking the question: are the new labor code applicable even if state government does not apply them?
No, on government organization, the all the codes are not applicable unless the government will apply. Actually, earlier also the labor codes are limited applicable on government organization, such as PF, ESI. All these government or government organization or governmental department have separate provisions for their employees.
Sir, Yogita Sangleji is asking the question from Mumbai. What about notice period in case of resignation? Will the days be counted from the completion of notice period?
Of course, it means the last day of working. There is no mandation or not any clarification on resignation period. It is on company's policy. Company may generally it is we can say that it should be 30 days. Still, if we are waiting for rules, if there is any clarification, we will of course update.
The CA Nitin Kedkar from Mumbai is asking, will presentation be available on site?
I'll share to you and you can share to all the participants.
Okay, thank you, sir. You may please share in the group.
Sure.
Sir, CA Ramesh Nayak is asking the question, what component of wages are there?
There should be a basic salary and other component you can choose as per your convenience.
Sir, again, question is asking from the Ramesh Nayak ji. Supplement allowance is a part of wages?
Of course, supplement allowances are part of wages, but these supplement allowances cannot be beyond 50%, more than 50% of total wages. If these are more than 50%, then the excess part will be added to basic wages.
Sir, CA Ram Samaira from Mathura is asking, opportunity for CA under new labor code like certification or audit or something else?
Existingly, there is no requirement of certification except in 2-3 cases, such as for BOC under BOCW Act for completion of building. However, under new rules which will be which will come in Feb or March, there is a chances of maybe opportunity for CA will be arises. So we are waiting for the rules.
Sir, Yogita Sangle ji is asking the question from Mumbai. Two questions she is asking. Is there any changes for gratuity like change in period?
Yeah, of course. Actually, gratuity for general employees, there is a limit of 5 years as it is. And for fixed term employees, the eligibility is for 1 year only. Fixed term employees now eligible gratuity even after completion of 1 year continuous service.
Again, she is asking for health checkup. Is there any cap on number of employees industry?
No cap.
Sir, CA Rohit Nagarat from Hospital is asking, what are the implications of voluntary registration for ESI?
Actually, implication is on like contractors. If we talk about contractors, there are certain requirement to take ESI registration even without having 10 employees. So due to their contract acquisition or so many things, so now they declare 10 employees even without having 10 employees, but due to voluntary provisions they will get ESI registration without declaring 10 employees.
Sir, K. Swaminathan from Madurai is asking the question, gig worker platforms workers, how differ from other employees?
Actually, gig worker platform, the provision under new labor code is that the government will issue gig worker platform and the employers of that organization such as Zomato, Swiggy, these will contribute under gig worker welfare fund, and the gig worker will get benefit from through registration of portals. Still, the portal is not yet launched. The government will very soon issue the portal, and after that, or of course it will also depends on rules that what provision will be immediate implicate in under rules.
Radhika Pandey from Gurgaon is asking the question. We are staff company, payroll of our clients run says from 15th December to 14th January, and salary paid on 1st February. ESI will be paid by 15th February. Is there any non-compliance of ESI as ESI portal accepts only a month wage, January wage, if a person join in December?
Actually, ESI, you are right. PF or ESI portal accept only calendar month, such as Jan, Feb, March. But you can choose wage period 30 for 30 days. For any 30 days, you cannot choose beyond 30 days. The only requirement is that if you are choosing 30 days other than calendar month, you have to pay on or before 7th of next month. For example, if your period is expiring on 14 December, so you have to pay on or salary or wage on or before 21st.
Sir, Prabhat Kumar Singh from Delhi is appraising that nice, excellent sir session, sir. Thank you, Prabhat ji. Now I'm coming. Narsima Murthy BR from Shimoga is asking whether contract employees covered under fixed term employment, and if so, gratuity is applicable after 1 year of work.
No, contract employees and fixed term employees are both separate. Actually, we can say that contract earlier they are contractual employees or contract employees. Now, contract employees have two part. One is fixed term employees and other one is contract employee. So, if the employee is contract employee, he cannot be fixed term employee, or if fixed term employee, then he cannot be contract employee.
Sir, Madhu Sudan T from Madurai is asking the question: will it be applicable to CA office with 7 staffs?
What actually there are some codes which will be applicable without in any limit, and if you are talking about any specific code or for any forex, it will better clarified after rules come. The limit of applicability will be clarified under rules also.
Rohit Nadarat from Hospit is asking, sir, for private sector, is labor code applicable if the state government has not made it applicable in their state?
Actually, these codes are enacted by merging, by repealing central laws. Okay, so state government role is limited. We have to follow these code with effect from 21st of November only.
Sir, Madhusudan T from Madurai is asking, what is the percentage of employees to get recognition as trade union?
51%.
Vidyut Kumar Roy from Mumbai is asking, mandatory component of gross salary. Basic is 50% of salary. Salary means CTC or gross salary.
Salary means the definition which is given under code on wages. Actually, there have two part. Which first is inclusion part. Inclusion part having basic, DA and retaining allowance, and exclusion part is having A2I, JK, A2K clauses. You can see on Google also the definition of wages, which is section 288.
Sir, C.A. Ram Samaira from Mathura is asking, could a CA firm take ESI registration and will it be applicable to partner salary to partners apart from employees?
No. Actually, if we are LLP, then and taking salary, then it will be applicable on such salary. But if we are partnership firm, then it is not applicable.
Madhusudan T from Madurai is asking, what is the number of employees for registration with ESI and PF? It's a last question, sir.
The existing limit is prevailing 10 for ESI and 20 for PF.
Okay, thank you so much, sir. On behalf of CP Committee of ICI, I am very thankful for giving your valuable time to share the wisdom of the knowledge with our participants of all over India on the Chartered Accountant on this 85th webinar on this most highlighted topic of the day, new labor code, new codes for the labor laws. Thank you so much to our chairman, CA Satish Kumar Gupta ji, CA Vice Chairman, CA Vishnu Kumar Agarwal ji for taking the opportunity for hosting this such a knowledgeable session with the fraternity members, and I hope that CPE committees is going to be complete 100th century of this webinar in very soon for sharing the knowledge with our fraternity members, community members. Thank you so much to the CPE technical team, the committee employees as well for arranging this wonderful session by contacting to the good and knowledgeable speakers of the day. Thanks to all of you and happy Makar Sankranti of this day and the different festive seasons of this month. Thank you so much. Thanks all about of the day. Thank you.
Thank you.